the governor can gather the information that is required, which raises a credible doubt as to the majority of a government in power. The only course open is a floor test. And that is what the governor goes ahead. You refuse to face that floor test. And your only answer to that is, it was a fait accompli. So, my lords, if democracies which have to be tested on the floor of the House are going to be decided on, it's my fait accompli, so I won't go and face a floor test, and yet want to continue in government, is that acceptable? Is that constitutionally acceptable? Rest your lordship on each of the questions referred, your lordship, because my respectful submission is going to be that a large number of the arguments have gone far beyond the questions referred. As I was respectfully submitting, according to us, a large number of arguments are far beyond the questions referred and really are not relevant to the issues at hand. Be that as it may. What is the basic premise of the case of the petitioners over the last 3.5 days? That because there was a split in the legislature party, we, the respondents, stand per se disqualified. And because we stand per se disqualified, ex facie disqualified under para 21A and 21B of the 10th schedule, the Supreme Court of India should bypass all coordinate constitutional authorities and decide itself whether we are disqualified or not, or in fact, effectively saying we are disqualified. Hold that. Secondly, till that disqualification is decided, neither should the floor test have happened, nor should the governor have taken a decision, nor could the ECI have taken a decision, because if ultimately they are held to be disqualified, it will have a bearing on the decision made by any of these authorities. And thirdly, because it is your lordship's order of 27th of June 2022 which led to the toppling of a government. Only your lordships can correct that wrong and restore status quo ante. Now, my lords, this fundamental premise on which the entire edifice of this case is based suffers from some basic problems before I come to the issues in hand. Your lordships have time and again held that we will not act as the court of first instance, especially where coordinate constitutional authorities have been specifically vested under the Constitution with the requisite powers to decide an issue. There is also a presumption that you are per se disqualified, so you're the jury, you're the judge, you decided yourself without any constitutional authority till date, having given any finding on our disqualification. You've decided, you've presumed it so. But more importantly, my lords, and before I get into the issues, I want to touch the issue of governor. It is of some concern. There were emphatic assertions made that when my Lord the Chief Justice and your lordships put a question, that what should the governor do in a case where not before the government is formed, but after the government is formed, there is a problem, should the floor test be ordered or not? What is the course of action that the governor should adopt? And the answer given was that floor test ought not to take place. Only a no confidence motion could be moved in such a situation. And Dr. Singhvi said that where disqualification petition is pending, my answer is 0 as far as holding of a floor test is concerned. Now, my lords, with utmost respect, these submissions of the petitioners are in the teeth of 9 judges of this honorable court in Bomai, are in the teeth. We are told that the concern in this matter is not about who wins and who loses, but maintaining constitutional propriety and institutions. And I think the arguments sought to be now forwarded before your lordships are destructive of the entire constitutional scheme as settled by your lordships in a catena of decisions, including the 9 judges in Bomai. also reiterated in Shivraj Singh Chauhan's case, where your lordships relying on Bomai said that it is incorrect to say that the floor test can only be directed to be ordered by the governor before a ministry formation and not after. In fact, your lordships' words used in Bomai and Shivraj were, it is the duty of the governor to hold a floor test. The only constitutionally ordained forum is the Assembly of Parliament, and no governor or individual in his own opinion can form a view whether a majority has been won or lost, and the only way forward is a floor test. And the court frowned upon the tendency because there used to be a huge misuse of Article 356 to dismiss governments and dissolve houses. So the courts frowned upon it and said that the first instance, the governor must call for the floor test in such matters. Now, my lords, what happens in this case? In this case, on the 27th, and in my earlier submission before your lordships on Navam Revia, I had even then said that I'm not for a minute suggesting that when we filed our 32, Nabam was not one of our cases. That's not our contention at all. Nabam was one of our important arguments. The other was equally important, was violation of principles of natural justice. And the third was imminent, immediate danger to the lives of the MLAs whose houses were being burned and relatives being threatened. That is why we came in a 32. And that is hugely different and was not barred by Quixote at all. Because our contention was not that your lordship decides on the disqualification petitions, as they are claiming. That was not the prayer in our petition. Our contention was that Nabam, even as it stands today, has held the judicial field. It is a constitution bench decision, and the speaker had no jurisdiction to proceed with the matter at all, apart from the principles of natural justice being violated. The court, keeping all this in mind, only on the issue of natural justice on that day, extended the time, did not injunct the speaker, extended the time. Now, extension is interpreted to say because extension was granted till 12th of July, it effectively meant an injunction. I don't see how. If you violate a provision of the rules which says adequate notice should be given, the speaker doesn't give that notice, the Honorable Court says gives them more time. Now, after that, my lords, what does the governor do? The governor in his letter writes to say that 7 independent MLAs who were supporting a ministry have withdrawn support. The leader of the opposition has written to me to say that they have no confidence in the ministry. Within the ministry, a large section of the legislative party have moved a resolution saying that they do not support the MVA ministry and government. Given these facts, I think it prudent and call upon the then Chief Minister, Mr. Thackeray, to come and prove his majority on the floor of the House. Lords, I put a question to myself, what else is the speaker, the governor expected to do? Your lordship's words again in Bomai are, by whatever process or means. The words used by your lordships in Bomai are, by whatever process or means, the governor can gather the information that is required, which raises a credible doubt as to the majority of a government in power. The only course open is a floor test. And that is what the governor goes ahead. You refuse to face that floor test. And your only answer to that is, it was a fait accompli. So, my lords, if democracies which have to be tested on the floor of the House are going to be decided on, it's my fait accompli, so I won't go and face a floor test, and yet want to continue in government, is that acceptable? Is that constitutionally acceptable? The only mechanism known is a floor test, and you evade that. And then you cast aspersions on a constitutional authority to say, which in any case today is the norm, you can cast any aspersion on anyone you want to. And you say that the governor in question failed to discharge his duties, acted with bias in a malafide manner. Whereas what was he expected to do? 7 independent MLAs say we have lost confidence. The leader of the opposition writes, 34 of the 55 MLAs pass a resolution saying we have no faith in the ministry any longer. Now, before I proceed further, my lords, I want and before I proceed, issue-wise, I want to show these two judgments. Because so much time has been spent on the powers of the governor and that he acted with malafide intent, and the solutions that your lordships asked for, what could have been done by the governor, it is said he definitely could not have asked for a floor test. And the only way to get out of all these judgments is to say that those cases did not involve a disqualification petition pending. Now, my lords, the moment your lordships in Shivraj Singh Chauhan, Kuldeep Bishnoi, and any number of judgments have said that, and Shivraj Singh Chauhan especially, that proceedings under the 10th schedule, which concern disqualification and a trust vote, operate in entirely different fields. In the meantime, the right of an MLA to participate in the proceedings of the House continues, and he continues to participate and vote. Now, my lords, if their submission is taken to be correct, firstly, it's wrong because it's in the teeth of what Bumai and Shivraj Singh Chauhan says. Then when your lordships ask them what could be done, they say zero definitely if disqualification petitions are pending, which is in the teeth again of Shivraj Singh Chauhan, which says that irrespective of disqualification pending, irrespective of resignation letters pending, they will participate in the House. And that comes back to the same question that if an MLA is permitted to participate in the floor of the House, the legality as far as those proceedings are concerned can't be questioned. You can't say that all proceedings, budgets, decisions, bills passed will all be annulled and we will restore status quo ante. And when I come to Rana, I'll point out to my lords, Rana is completely misread. Rana was in the context where the speaker's power, the Supreme Court held that when the speaker decides the disqualification issue, he sees the events as on that date. Because there, a set of MLAs had gone and shown support to a rival faction and gone to the governor. The split took place later. They sought to seek the defense of the 10th schedule as it then existed. The Supreme Court ultimately said no. As far as the governor is concerned, the facts will be seen on the day. When they approached the governor, the Supreme Court never said that the MLAs who participated in trust votes, the MLAs who've taken decisions, proceedings which have been legally conducted, will all stand annulled. Because ultimately it comes down to the argument being that if ultimately your lordships were to hold them to be disqualified, the EC proceedings couldn't have gone on, the trust vote could not have happened, and thus restoration of status quo ante, which would mean annulling everything that has happened. That's effectively the argument being made before your lordships. To stay the EC proceedings, 4 hours of arguments were addressed that EC should not go on with the same argument. That if EC goes ahead with it and later on it's found that these people are disqualified, they have no right to approach the EC. And a question was put by our lordships even on that day, what about his right as a member of a political party? In any case, who will decide this? Whether there has been a split in the political party, and then you presume, as if I have argued that there is only a split in the legislature party and not in the political party. We have consistently said so, including in our resolution dated 21st of June 2022, that a legislature party is integral and organically connected and co-joined to a political party. What is said in the legislature party is a reflection of what is happening amongst millions and thousands of cadres of the Shiv Sena across the country, because there was a huge discontent of aligning in the MVA with people who you were ideologically opposed to right through your political careers and existence. That was where the discontent arose from. That you fought an election with another party, after that suddenly we went along with another party. That was the political discontent. So we were conscious and rightly talked about the political party discontent. But who will determine this? Who is the whip? There are 2 whips we are talking about. They say your whip is only appointed by the legislature party. We say no. To say that our whip appointed by the legislature party does not represent the authority of the political party is wrong. Ultimately, right or wrong, the EC today has taken a decision. That's the subject matter of another petition which your lordships will decide. But even on that day when a stay was asked for, our respectful submission was, how can the Supreme Court today, without the concerned constitutional authority at all deciding on the issue, take a call on these matters? Just because you say so and you presume we are per se disqualified. Now, please have, my lords, Bumai and Shivraj Singh Chauhan only on the powers of the governor before I proceed, because that's one of the most glaring submissions made in the teeth of settled law of the land. Please, for the judgment.
So your submission starts with the primary principle that proceedings under the 10th schedule operate independent of the power of the governor. Irrespective of the pendency of the 10th schedule proceedings at any point of time, the governor can ask a floor test.
And
number one. And if he asks, then are there any limitations with respect to the fact that the 10th schedule proceedings are pending? Should he wait, not wait? Because the primary question will depend
yes,
upon.
I bow down. My lords, I bow down. Your lordships have summed it up very well. May I just add to what your lordships are saying? In addition to what your lordships summarized, is my second limb of the argument that your lordships have already held in any number of judgments that an MLA during pendency of a disqualification petition is fully entitled to participate and vote. If that were so, then what is the hindrance to a floor test being conducted? And in all those matters, the issue arose the same. During pendency of disqualification petition, should the floor test take place or not? I'll show those paras. And your lordships answered by saying, why should the floor test not take place in the meantime? You can't, without the decision of the speaker, say that a person is disqualified.